Hey folks, Human Rights Attorney Leigh Dundas coming to you this Saturday, January 11th in 2025. I want to talk to you today about a case that I really think you should know about. It involves a little girl who alleged sexual abuse at age 4.5, which had allegedly occurred at the hands of her biological father, a policeman, and her paternal step-grandfather. Now, the paternal step-grandfather was already on the offender registry in their state for having admitted to detectives before the little girl was even born that he had raped a teenage, wheelchair-bound, brain-injured physical therapy patient of his who had worn short shorts, and that he had vaginally and orally been raping her for a period of 2 years since she was basically 13 years old. The 4-year-old's investigations at the time they were made were deemed credible, and based on that, a search warrant was issued for the sex offender's basement where the little girl had alleged that her father and the grandpa would abuse her. And when the cops went into that basement and turned their special lights on, they found not 1 or 2, but 6 different stains suspicious for seminal fluid. So when they cut out those pieces of carpet and sent them to the state forensic lab, what came back from the lab was as follows: that it was, quote, at least 160 septillion times more likely if it, meaning the stain, originated from the father than if it originated from an unrelated, unknown contributor. And it was at least 320 quadrillion times more likely if it originated from the grandfather than if it originated from any other unrelated, unknown contributor. So I had to look up a septillion. It's actually 24 zeros after the 160. There were other really big numbers in reference to those stains that came back from the lab: 10 billion, 13 trillion, 6.1 quadrillion. Long story short, in prosecutor speak, this is what we call a rock-solid, open and shut forensic case. So based on all of that, the courts issued arrest warrants for the 2 gentlemen, and when the father was arrested and they seized his electronic devices, not 1 but 2 different law enforcement officers subsequently testified under oath that they found pictures of, quote, naked pictures of both boys and girls that appeared to be possibly prepubescent, and also images of, quote, very young children involved in blank acts with adults, and very young children appearing to be blanked and or in bondage. The state, however, decided in its infinite wisdom to not prosecute this incredibly strong DNA case, nor the separate standalone case for what was found on the devices. And now that they failed to prosecute it, the dad was rendered a free man, at which point he moved the state of Florida courts to get 100% sole physical custody of his kid back. The judge in that particular case in the Florida family courts prevented the therapist on the case from talking about the abuse with the little girl, prevented the mother from talking about the therapy to the little girl or the abuse with the little girl. And he also ordered the therapist to not report to authorities when they inquired if they should. And moreover, when the little girl, who was now 9 years old, told the judge on the record that sometimes, quote, he, meaning dad, would make me take off my clothes and he would videotape me with his cell phone dancing, the judge actually sealed that transcript. So it's likely that nobody ever heard about or saw those allegations or could thus follow up. And hold on to your hats and glasses, folks, because it gets even more strange. The judge then held the mother in contempt of court and fined her $237,000 for what, you might ask? Well, for the audacity of having taken her child to see therapists and for having cooperated with an ongoing criminal investigation by another state's attorney general department. The child custody hearing was this past Monday down here in Alachua County, Florida, where the new judge agreed with the old judge that they weren't going to hear any of their sexual abuse, alleged molestation evidence, because it was not credible. And they, moreover, even prevented the now 14-year-old child, almost 14-year-old child, from even testifying as to whom she wanted to be with. The judge then summarily ruled, after hearing the father's day of evidence and before hearing any of the mother's evidence, that custody would go back to 50-50 split immediately, unsupervised. To learn more about this case or get involved in it, go to Leigh Dundas, LEIGHDUNDAS.com, and click on the page that says Child Rape Case. You can see photos of the crime scene. You can see photos of the lab report. You can also see the underlying state police reports. I link out to those. And you can see the 2-hour press conference I did going over all of this data on the courthouse steps. And you can help the mother by funding her nearly $2 million worth of legal fees she's incurred over the last 10 years. I'm not taking a dime. I'm just helping this case get known. Take care, guys.